Good evening and welcome to Guildford Chambers Children Public Law Update 2022. My name is Suzanne Kelly, and this evening I'm going to be looking at vulnerable clients, the need to establish whether your client needs an intermediary at the earliest opportunity, and the consequences of failing to do so, the local authority's duty to clients with a disability, and then looking at intermediaries themselves. So competency and whose responsibility it is to determine that, and cost orders against intermediaries and third parties when it all goes wrong. So turning first to vulnerable clients. In recent years, courts and tribunals across the English and Welsh legal system have recognised the need to make provision for vulnerable persons to participate in proceedings. In family proceedings, these rules are set out in Part 3A of the Family Procedure Rules, vulnerable persons, participation in proceedings and given evidence, introduced in 2017 and supplemented by Practice Direction 3AA and Practice Direction 3AA. Interestingly, there is no definition of vulnerability in the rules, but the provisions plainly extend to those persons with comprehension and some learning difficulties. So I want to speak about a case called Re S, Vulnerable Party Fairness of Proceedings 2022, in which the court set out the rules in some details. Rule 3A4 headed the court's duty to consider how a party can participate in the proceedings provides that the court must consider whether a party's participation in the proceedings, other than by way of giving evidence, is likely to be diminished by reason of vulnerability, and, if so, whether it's necessary to make one or more participation directions. Before making such participation directions, the court must consider any views expressed by the party about participating in the proceedings. Rule 3A1, headed Interpretation, provides that participation direction means a general case management direction made for the purpose of assisting a witness or party to give evidence or to participate in proceedings, or direction that a witness or party should have the assistance of one or more of the measures in Rule 3A8. Rule 3A5, headed the court's duty to consider how a party or witness can give evidence, provides that the court must consider whether the quality of evidence given by a party or witness is likely to be diminished by reason of vulnerability, and if so, whether it's necessary then to make one or more participation directions. And again, before making such participation directions, the court must consider any views expressed by the party or witness by giving evidence. In the interpretation section in Rule 3A1, it is stated that references to quality of evidence are to its quality in terms of completeness, coherence and accuracy, and for this purpose, coherence refers to a witness or party's ability in giving evidence to give answers which address the questions put to the witness or party and which can be understood both individually and collectively. Rule 3A8, headed Measures, provides inter alia. The measures referred to in this part are those which provide for a party or witness to participate in proceedings with the aid of an intermediary, provide for a party or witness to be questioned in court with the assistance of an intermediary, or to do anything else which is set out in Practice Direction 3AA. An intermediary is defined in Rule 3A1 as meaning a person whose function is to A, communicate questions put to a witness or party, B, communicate to any person asking such questions the answers given by the witness or party in reply to them, and C, to explain such questions or answers so far as is necessary to enable them to be understood by the witness or party or by the person asking such questions. Those provisions in the rules are supplemented by Practice Direction 3AA, paragraphs 1.3 and 1.4 of the Practice Direction provide that it's the duty of the court and of all parties to the proceedings to identify any party or witness who is a vulnerable person at the earliest possible stage of any family proceedings. All parties and their representatives are required to work together with the court and each other to ensure that each party or witness can participate in proceedings without the quality of their evidence being diminished and without being put in fear or distress by reason of their vulnerability, as defined with reference to the circumstances of each person and to the nature of the proceedings. And those provisions clearly also refer and are relevant to persons that have suffered from domestic abuse and Practice Direction 12J, although I won't be considering those this evening. Paragraph 3.1 gives guidance about the assessment of a person's vulnerability and its impact on their participation in the proceedings. Section 4 and 5 of the Practice Direction give guidance about participation directions, including with regard to participation other than by way of giving evidence, directions about the structure and timing of the hearing and the formality of language, and with regard to giving evidence, the convening of ground rules hearing and directions about the conduct of cross-examination. The provisions are a key component of the case management process, which ensures compliance with the overriding objective of enabling the court to deal with cases justly, as observed in Re NHR 2019. Oh, excuse me. Part 3A and its accompanying practice direction provide a specific structure designed to give effective access to the court and to ensure a fair trial for those people who fall into the category of a vulnerable witness. A wholesale failure to apply the Part 3 procedure to a vulnerable witness must, in my mind, make it highly likely that the resulting trial will be judged to have been unfair. So that takes us on to the case of Re S, which is a very interesting case because the appeal arose from a fact-finding hearing that took place during January and February of 2021 in care proceedings involving a girl, S, then aged 6.5, where the principal issue arising in the hearing was the cause of injury sustained by another child, JD, a boy then aged 5.5, who was not the subject of those proceedings, but who became the focus of the proceedings because his injuries were sustained around the weekend of 18th to 19th of January 2020, during which he spent a period of time in the care of S's mother, referred to as X, and her father, referred to as Y. JD was a non-verbal child. He had a significant hearing deficit and required to wear a hearing band, and he had developmental delays. So he was a vulnerable child in himself. In the period between the fact-finding hearing and the appeal, S had been removed from her parents' care and was living with family members, whilst JD and his brother remained at home with his mother and his brother. In 2019, by way of a brief background, and it is a brief background because this was a very lengthy and complex case, but in 2019, JD and his older brother had been the subject of an assessment by the local authority's children's services as a result of their mother's misuse of ketamine. Concerns had also been raised about bruises and marks seen on the child at school. In the weeks leading up to the weekend of 18th to the 19th of January 2020, JD spent periods of time in the care of X and Y, who were friends of A, or there was a dispute as to how often this had occurred. In the days before the weekend, JD attended school where staff there observed no marks on him. At about 4:30 on Saturday the 18th, JD was handed over to X to spend the night and following day with her, S and S's father. At the hearing, there was a dispute between the adults as to whether there'd been any marks on JD at this point, and the mother of JD said there was no marks. The mother of S saying there'd been a mark on the side of the face. Over the next 24 hours, according to S's mother and father, various accidents occurred which they later suggested could have caused some of the marks subsequently seen on JD. For example, it was alleged that JD had fell in a ditch while playing in the woods and he'd hit a radiator after jumping on a bed. A number of text messages had passed between S's mother and JD's mother during this period, which were adduced in evidence at the hearing. JD was returned home to his mother at around about 8 o'clock on Sunday, the 19th of January. And it was JD's mother's evidence that she then noticed abrasion on his left arm, although there were some inconsistencies in her various accounts as to what she saw and when. But she did text S's mother to ask what had happened to JD's arm. And in reply, S's mother said she hadn't seen anything. The local authority instigated an investigation under Section 47 of the Children Act, and a medical examination of Jay disclosed a total of 23 marks, bruises and abrasions, including a series of marks and abrasions on the left side of his face, amongst which were linear marks extending to his ear, a deep abrasion or burn on the left forearm, various bruises on his buttocks and thighs, and some superficial abrasions on the front of his penis. The conclusion of the examining doctor was that at least some of the injuries were non-accidental. At the conclusion of the hearing, which was held remotely over approximately 8 days and was adjourned on more than one occasion due to S's mother's alleged ill health, Her Honour Judge Nisa found that most of Jay's injuries had been sustained accidentally, but some had been inflicted by his mother, who had been joined as an intervener. Clarity on judgment was sought, and Her Honour Judge Nisa handed down a revised judgment which dealt with some but with not all of the issues raised, and accordingly permission to appeal was sought from Judge Nisa, which was refused. There was a delay in submitting an application for permission to appeal due to funding issues, and the application for permission to appeal those findings was submitted on the 15th of July 2021. The appeal was initially made on the following grounds, and there were 6 grounds in the initial appeal. The first was procedural irregularity and unfairness, and that being the court made findings against the intervener which exceeded those sought in the schedule of findings and provided no reason for doing so, and made findings against her in proceedings not related to the welfare of her child and into which no relevant social worker evidence was produced. That the court had departed from the view of the experts Dr. Goddard's opinion in respect of the injuries to JD and provided no reasoned judgment for doing so. That the court had erred in its application of the fact, that it had fallen into speculation and made findings which had no base in facts, and the court had made findings in respect of the injuries which were contradictory and such that there was no basis in the evidence. They could not be reasonably explained or justified, and were ones that no reasonable judge could have reached, and that the court failed to give proper consideration to the fact that S's father failed to attend to give evidence, and that the court failed to properly draw adverse inferences which would have significantly affected the findings. On the 24th of September, Peter Jackson refused permission to appeal on the first ground, but granted permission on grounds 2 to 6, and the appeal hearing was fixed for the 23rd of November, with directions given for the filing of skeleton arguments. During the intervening period between then and the hearing being heard, the local authority had, some months after the findings were made during the course of those proceedings, issued proceedings in respect of JD and his brother. During those proceedings, the mother underwent a cognitive assessment by Dr. Gary Taylor, which identified no cognitive issues and no need for special measures. And it is of note that Dr. Taylor's report was also undertaken remotely due to COVID. It wasn't until a further assessment by Dr. Joslin in September suggested that JD's mother may be assisted by an intermediary, and in fact her cognitive difficulties far exceeded any consideration that had been provided by Dr. Taylor. And at this point, an application was made to amend the ground of appeal to reintroduce procedural fairness and irregularity as it was anticipated that the mother of JD would benefit from an intermediary. And that appeal point was heard first as a preliminary issue. Identity is vulnerable. In the case of Riex, a case had progressed without that having been identified. What the court said was that it will almost invariably, rather than the court witness, it would be I may have dropped out then. So as I was saying, it will almost invariably one of the parties or their representatives rather than the court who first identifies that a party or witness is or may be vulnerable, and that they consider good practice requires the party's representatives actively to address the question of whether a party is vulnerable at the outset of care proceedings. Indeed, as social workers will as a matter of course be looking for vulnerabilities in family as part of their practice, it is to be hoped that this issue will be identified before care proceedings are started. They went on to say, we recognise, however, that it's often not easy to identify vulnerabilities and that professionals dealing with urgent and difficult situations in families will have to contend with a large number of issues. And for that reason, we consider that to comply with the obligations under Rule 3A.9, the judge conducting the case management hearing at the start of care proceedings should, as a matter of course, investigate whether there are or may be issues engaging Part 3A of the rules, and that the parties' advocates should, as far as practical, be in a position to respond. And whilst I can recognise that the need for that, I have to say from my experience, I have never known a judge raise that at the start of any care proceedings, and it is often left to either the advocate or those instructed on behalf of a party to raise it with the court. In the case of Ries, it was not until the end of her giving evidence that her counsel representing her began to have some concerns as to her understanding, although it was not clear that these were cognitive issues as opposed to misunderstanding questions, which were long, complex and multifaceted, whether the client was tired, had had a long and stressful day giving evidence, or was just, as we have all had, a less than satisfactory witness. She'd been able to give clear instructions and appeared to understand the advice provided and the proceedings. And indeed, at the conclusion of her evidence, when this was explored with her, she had confirmed that she'd understood everything, but had just got a little confused as to dates. The court in Ries observed, with the great benefit of hindsight, that legal representatives should be particularly vigilant to detect possible vulnerabilities in their clients when they are unable to meet them in person. Noting in this case that neither counsel nor solicitors instructed on behalf of the intervener had been able to meet the client in person until the appeal hearing. All instructions had been taken over the telephone. The client had suggested that she was dyslexic, and therefore careful explanation of all issues had been given and her understanding checked. It's also of note that because she was an intervener, the proceedings didn't refer to her child in the welfare issues. She had limited input from the local authority and the social worker, so there wasn't that hands-on intervention that might have identified some issues with her cognitive ability prior to the proceedings. The court recorded that the need for an intermediary was not identified in the initial cognitive assessment carried out by Dr. Taylor and Ms. Howe in June 2021. And it was only during the subsequent proceedings concerning the intervener's children that the extent of her difficulties became apparent following an unrelated assessment carried out by Dr. Josling in September 2021, as I've already referred to. And there was a subsequent Communicore assessment which arose from those recommendations. the communicable recommendation for an intermediary being received via email the night before the appeal hearing on the 18th of September 2021. Oh. Now, the way in which the mother gave her evidence and the impact of not having an intermediary was key to this appeal, because the judge had clearly formed a view of the mother, or the intervener rather, and a negative view in respect of the evidence that she gave. And what the judge said was this. Having considered the evidence about the issue, the judge observed that she had lied, and it was, in my view, not because she is embarrassed. She has far more to hide and quite a lot to lose in that regard. Even in her evidence, she did not seem to give it the seriousness that she ought to have done. She was still in partial denial, but by her attitude, she was trying to state that it was something that was wrong with the results. I was not impressed by her evidence. The judge went on to say that I would say that she was very deflective and able to answer the questions in a way that lost the actual question. I would say that her answers were very calculating, and I think she certainly started the campaign to point the finger at S's mother in these proceedings to deflect away from herself. So in giving judgment, Baker said the following. We have reached the clear conclusion that the failure in this case to identify A's cognitive difficulties and to make appropriate participation directions to ensure that the quality of her evidence was not diminished as a result of vulnerability amounted to a serious procedural irregularity, and that as a result the outcome of the hearing was unjust. Of course, conducting the hearing over 9 days, the judge was in the best position to make an assessment of the demeanour and competence of the witness, albeit in a less than optimal conditions via a video link. But the new material that we have now read has an obvious bearing on the demeanour and credibility of the appellant. In some cases, there will be other evidence supporting the findings, so that a flawed assessment of a witness's evidence will not warrant any interference with the decision. In this case, however, the judge's assessment of A's character and plausibility of the witness was central to her ultimate findings, and accordingly the appeal was allowed. So, looking now at the duty of the local authority working with parents with a disability, none of this is new law, but it's something that I hold quite dear to my heart, having represented many clients who have some learning educational difficulties that don't actually mean that they need an intermediary or any special measures, but it does mean that they are, or they should be, dealt with differently, I say, by the local authority. So the Good Practice Guidance on Working with Parents with a Learning Disability was published in 2007 and then updated in 2016 by the Department of Health and the Department for Education and Skills. And it sets out how children's and adult services can and should work together to improve support to parents with a learning disability. Failure to apply the principles of the Good Practice Guidance is detrimental to the children's welfare and amounts to a breach of theirs and their parents' rights, such as those under the United Nations Convention on the Rights of the Child and the United Nations Convention on the Rights of Persons with Disabilities, the Equality Act 2010 and the Human Rights Act 1998. Interestingly, dyslexia comes under as recognised as a disability under the Equality Act. However, from my working experience, I don't think I have ever seen a local authority work with a parent with dyslexia any differently than a parent who does not. And certainly I have not seen any parent with dyslexia given any different treatment. All too often I find at a final hearing, the local authority's final evidence will be littered with comments that the person has failed to take on board advice, failed to understand the local authorities' concerns and failed to make any changes. And perhaps if they dealt with the issues better, that would not be the case. Parents with learning disabilities must be given every opportunity to show that they can parent safely, be good enough parents with appropriate support, and failure to build in from the outside the extra time a parent with a learning disability needs in order to understand puts that parent at a significant disadvantage in child protection proceedings compared to a parent without a learning disability. And this guidance was referred to with approval and applied in a local authority and G 2017, where at paragraph 38 it was said that services need to enable children to live with their parents as long as it's consistent with their welfare by providing the support they and their families require. This accords with the general duty of local authorities under Section 17(1) of the 1989 Act to provide a range and level of services to safeguard and promote the welfare of children in need and their upbringing by their families, insofar as it's consistent with their welfare. And whilst this case highlighted the importance that all families where one parent or more have a learning difficulty are given the help and support they require to be able to care for their children, the judge in this case found that the obligation does not extend to support that is tantamount to substituted parenting. The President of the Family Division, James Mumsby, provided updated guidance in 2018, having considered the various important procedural and substantive issues in relation to parents with a learning difficulty. I've set out the cases there that he considered. He went on to say in his guidance that his primary purpose in issuing the guidance was to bring to the attention of judges and practitioners and to commend for careful consideration and application by everyone the very important good practice guidance on working with a family with a learning disability issued by the Working Together with Parents Network and the Noah Fry Centre in 2016. And I certainly hope that that is something that is endorsed by the court. Moving finally to intermediaries and competency. The court considered this issue in a local authority, Mother and Others 2020 and 21. This is where the local authority parents and children's guardian brought an application for costs against DM and HM intermediaries. The substantive matter before the court was the local authority application for care orders, in which both parents were assessed as requiring the assistance of an intermediary for fair participation. On the 26th of May 2021, DM was approached and he accepted instruction to act as an intermediary for the father. He'd frequently acted as an intermediary and also as an agency for other intermediaries, and it is of note that there was no criticism of his competency. However, on the 14th of July, he notified the father's solicitors that he would not be available. He put forward MH to stand in his place. He presented MH as a competent intermediary by way of an email, stating that MH has acted as an intermediary for XX numerous times and comes with the experience of special educational needs. She's competent and available and able to serve for the duration of the listing. And I will completely hand over. Would this be okay? Please do confirm ASAP, and I apologise for not being available as stated. Written questions for the father had been prepared in advance and agreed at a ground rules hearing as part of the IRH. Standard part of the role of an intermediary to consider such questions and ensure that they're appropriate for the party being assisted. At the end of day 2 of the trial, on the 20th of July, after hearing the evidence of the mother, the local authority informed all parties of the intention to revise the questions to be asked of the father and said she'd provide those to MH on the following day. At that point, it became crystal clear that MH had not seen the original list of questions to be put to the father, which had been agreed at the ground rules hearing, had not read the father's cognitive assessment or his intermediary assessment, and had no knowledge of the relevant advocate's toolkit. It further transpired that MH was a friend of DM, having met him 5 years ago in her capacity as an English teacher. When describing herself to the judge, she described herself as supporting individuals as a life coach, and her experience as an intermediary spanned 2 weeks. The court determined that MH seemed to have no appreciation of an intermediary's role in the hearing. The judge noted that it appeared that she'd acted as an intermediary on one previous case in June 2021, again having been proposed by DM. Justice Levin determined that DM's email to the solicitor in that June case was relevant to the application of costs before the court, as on the 22nd of June 2021, DM wrote to the assisted parties' solicitors as followed. I appreciate the importance of progressing on this case. As mentioned, it's been difficult to assign the overwhelming number of intermediary requests within my team that includes consultant psychiatrists who often step in to help out. The case tomorrow will have MH act as an intermediary, where I have prepared for her the role in which she has limited specific experience. MH is well versed in communications, having taught English, and has been in care as a provider and in supportive special care needs. As already looked at, the role of intermediary, the definition is not clear, the duties is not particularly clear, and as we've already looked at, it's defined as a person whose function is to communicate questions and to communicate to any person asking such questions the answers, and to explain the questions or answers insofar as it's necessary to enable someone to be understood. There is no further guidance or rules on the duties, trainings or qualifications of an intermediary in the family justice context. The criminal courts, where intermediaries were introduced in the Youth Justice and Criminal Evidence Act 1999, the Ministry of Justice produced guidance in Registered Intermediary Procedural Guidance 2020. This document sets out a code of ethics and a code of practice for registered intermediaries, as well as detailed guidance on the duties and functions of a registered intermediary. In this case, the court concluded that intermediaries, as we know, perform an extremely important function in ensuring a fair trial for highly vulnerable people in the family courts, usually parents, and that it's of great importance that they do a job to a professional standard and their role is properly considered and monitored, both at the stage of their appointment and during the conduct of the relevant hearings. Although intermediaries, certainly in the family courts, are not subject to any regulatory scheme, they are part of the justice system and they are paid for their services by HMCTS. As such, they should be held to professional standards appropriate for the role that they are being paid to undertake. It would undoubtedly be helpful if these were set out in one document in a similar manner to the Ministry of Justice guidance in relation to intermediaries in the criminal court. DM and MH had both been made parties to the cost application. They were not parties to the substantive application. And they were given the opportunity both to submit any written submissions and evidence to make oral submissions. DM submitted a written statement and he gave oral evidence. MH did not submit a statement, but she did give evidence. In his written statement, DM argued that it's incumbent upon the trial judge to ensure that the intermediary is competent and that the judge did not do that. He also said the court was not obliged to use MH and the solicitors were not obliged to put her forward. His final submission was that the responsibility was therefore on the court and on the solicitors to ensure that she was competent to perform the role. The court unsurprisingly rejected DM's argument that it was incumbent on the judge to ensure that the intermediary was competent, and Justice Levin concluded that as soon as the judge was alerted to the problems with MH, she undertook all appropriate steps. And she went on to say at paragraph 48 of her judgment, it is not for a judge to conduct an initial examination of an intermediary, any more than it is for the judge to test the competence of an interpreter. In practice, it is the assisted party solicitor who is expected to ensure the intermediary is appropriate. But in this case, the solicitor reasonably relied upon the assurances given by DM. And it must be remembered that the intermediary is supposed to assist the party in the court and not be an additional burden. I have to say that came as a little bit of a surprise to me. I certainly, prior to reading this, was not aware that that the responsibility for ensuring an intermediary was competent lay squarely with the instructing solicitor or indeed any counsel at court. I certainly would not feel comfortable assessing an intermediary's competence at court unless there was something glaringly wrong about the way that they interacted with a client. So moving now to the costs, the application for costs was made under Section 51 of the Senior Courts Act and FPR Rule 46.2. Section 51.3 provides that the court shall have full power to determine by whom and to what extent the costs are to be paid. The ability to make a costs order against an expert was considered and confirmed in Re ABCDEF 2019. And the principle that a third party who is not a funder but who is involved in court processes can be subject to a costs order is established. In this case, the judge noted the tests under the wasted cost regime in Section 51.6 and in Radley and Horsfield in 1994, where the court applied a three-stage test. Namely, 1, did the legal representative act improperly, unreasonably or negligently? 2, did that conduct cause the applicant unnecessary costs? And 3, was it just in all the circumstances to order costs? Although this was not a wasted costs application, the approach was deemed to be analogous with those applied to in applications against third parties. Although the application for costs was made against DM and MH, and the local authority argued that they were both responsible for the collapse of the final hearing, the main focus of the argument was upon DM. The requirement for causation between the third party's action and the cost incurred was clearly established. There was no doubt that without the behaviour of DM and MH, the wasted costs would not have been incurred. The court considered that DM had acted inappropriately in putting MH forward as an intermediary, given her very limited experience and complete lack of training or preparation for the role, without at the very least, fully explaining the position to the solicitors. His failure to act appropriately in this regard directly led to MH being appointed and to the hearing collapsing. And the court therefore had no difficulty in making the cost order against DM. No cost order was made against MH as the court considered that she didn't act improperly or wrongly and that she hadn't fully understood the role of an intermediary. And that concludes my talk for this evening, and I do hope that you have found it to be useful.